If it may please the court, my name is Thomas Flynn, and I'm here today to represent Taylor Smith. I am here to argue whether or not a release sponsored by a commercial or non-commercial entity is signed by a parent or guardian on behalf of their minor child is legally enforceable. I am here to prove that the release signed by the parent of Sammy Mallory was fully enforceable due to the rights of the parents being unconstitutional to be infringed upon in this situation of the release being signed for school or community activity which fell under the trip that was taken by the Wilderness Scouts. It is clearly proven and stated in the case Fields v. Curtin that the mother's own judgment in the signing of a case is held under her own responsibility, stating that any waiver executed by a parent on behalf of a minor is supported by public policy when it releases to obtaining medical care, insurance, participating in school or community sponsored activities, which clearly falls under the trip taken by the Scoutmasters.
In what sense should the mother be held accountable for the death of her child, which was clearly caused by an outside factor?
The mother had clearly signed the release stating that all liability of what could have happened during that camp was held responsible for her, the parent. Any damage or injuries or even death that could have happened at that camp was held under the release that she signed. It was the mother's responsibility to fully read through and comprehend the release before she signed it, knowing fully that she would be held responsible for any liability that could have happened while her daughter was there.
Why should the mother be held accountable for this tragic event, even though it was not specifically disclosed under the permission slip?
The release signed by the parent was just and was made with the intent of protecting the child in mind. The release did not leave out any important key details that would have been needed to know the full scope of what you'd be agreeing to with signing this document. What happened on the night was completely unexpected and was covered under the release signed. The release covered all injuries, anything that could have happened under the Wildlife Scouts trip. You were reliable for by signing that under your minor child. This release is just and is in the best interest of the child.
Is this release signed truly, just, and made with the intent of fully explaining what this signer is responsible for upon one's agreement?
It is clearly stated under this agreement, stated in the permission slip signed by the parent, that by signing this, you are taking full liability of any possible injuries of your child, in that you are releasing the Wilderness Scouts and employees of any reliability relating to injury, loss, or damage while participating in the camp. It had no specific wording relating directly to any kind of event that could happen. It was disclosing simply under loss, injury, or death. It had no reason to fully disclose under any specific event to happen. It simply stated that you are taking full liability of anything that happens under this camp, regardless of what unfortunate event may have occurred on that night.
Would the context of this specific case truly call for the clearing and pursuing of the enforcement of the release, considering this would not have been in the best interest of the minor child?
Yes, it definitely must be enforced. As stated in State v. JP, it is completely up to the parent to use their own justification and their own belief to decide what activities are responsible enough for their child to take part in. It is up to them to decide what is right for their child due to the fact that they are still a minor and that they have say in what they participate in, due to them being the ones having to sign the legal documents because they are of age and hold supervision of their child.
Does this release not lack necessary clear details that would be key to the full agreement of the parent?
No, this release does not lack the clear necessary details that the parent would need in order to fully agree to the liability as seen in the release. Regardless of the unexpected events that happened on the night, no matter how tragic they were listed on the release. They may have been very unexpected, they may not have been specifically detailed, those events, under the release, but they were cleared under what was specified under the parent's liability for signing this in their child's name. This release signed by the parent must be enforced. The liability, as stated in the document, covers everything that happened during this event. The parents signed this knowing full well that they would be taking full responsibility for the liability of their child. My name is Thomas Flynn, and I thank you for your time.